Thank you for joining us for Restructuring Insolvency and Troubled Companies 2025. This is episode 2, Opportunity Amidst Crisis, Buying Distressed Assets, Claims, and Securities for Fun and Profit. My name is Thad Wilson, and I'm your moderator today. This webinar is part of the Financial Poise webinar series, Restructuring Insolvency and Troubled Companies 2025. Slides 7 and 8 provide a summary of the series, and slide 6 summarizes this episode. Speaking of the slides, you should understand from the get-go that we will not step through this PowerPoint in order, nor will you have to listen to us read any of the slides today. This webinar, like all other Financial Poise webinars, is a conversation. But keep the PowerPoint handy because I will try to indicate what slides our conversation is touching on as we proceed, so that way you can take notes. The conversation we're about to have is meant for general education purposes and does not replace the need to consult with an attorney, accountant, or other appropriate professional. Our esteemed panelists today are Peter Amidst, a partner at Alston & Bird in New York, Richard Corby, a partner at Corby Law in New York, Jonathan Friedland, a partner at Much Shellist in Chicago, and me, my name is Thad Wilson, and I'm the head of the Bankruptcy and Insolvency Litigation Practice at King & Spalding in Atlanta. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us, but you can read more about us on slides 67 through 70. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. And a special shout out today and thank you to our sponsors and co-producers, the great folks at the National Law Review, Max Asset, and the Daily DAC. There's some info on these great sponsors and co-producers in the materials. So with that, let's jump into our session today. So Peter, I'm going to start with you. We're here to talk about distressed acquisitions. With a lot of distress in the real estate, healthcare, auto, retail, and restaurant industries right now, what are some of the reasons buyers might want to acquire assets in a distressed sale? And for someone who's a rookie at the process, how might you identify opportunities and what is a good place to start?
Sure. Thanks, Ted. And it's great being here with everybody today. In terms of like why buy distressed assets, well, I mean, it's an opportunity to purchase assets generally at discounted prices and on more favorable terms than if you were to buy similar assets outside of a distressed setting. So buyers could see an opportunity to, of course, like buy low and sell high, especially if the market recovers or the asset can be repurposed or improved. It's important to note, though, that distressed assets can sometimes carry a higher risk, which may present opportunities if the buyer can restructure or turn around the underperforming asset. And there are firms that specialize in this type of work. Sellers, it's also, noteworthy to mention that sellers are often under pressure to close quickly because they're in need of liquidity. And so that can give buyers negotiation leverage and the ability to sometimes demand more favorable terms. And then we have seen from time to time, of course, distressed sales opening up an opportunity for a company to make a strategic acquisition to facilitate market entry or expansion or to eliminate competitors. And then, Thad, you mentioned, well, if you're a rookie, like how do you look for opportunities? I think just as a general matter, because distressed assets often carry a greater risk, it's wise to start small and build experience gradually. So if I'm starting out, I'm going to look for less complex deals to start and then learn the process by engaging in smaller transactions. So the first step is to identify what specific asset or asset class is of interest to you, right? It could be real estate, a particular business, whatever. And then study that market to understand the factors that lead to distress in that sector. In terms of finding opportunities, public auctions, foreclosure sales, bankruptcy filings are useful. Public notice of bankruptcy and foreclosure auctions has to be provided under applicable law. So the first step in getting basics, and so that these can provide, the first step in getting basic information about what assets are being sold. And then just like more generally, I would just say it's important to network with industry professionals who deal with distressed assets, bankruptcy lawyers, auctioneers, investment bankers. Um, and you really need to do your due diligence to understand the risks because most of these distressed assets are sold as is. So you really need to know what you're buying. And as deals get more complex, it's important to consult with experts like us or bankers who can help guide you through the process.
Well, that's great. And I'll put in just a quick plug here for the Daily DAC, one of our co-producers today, who runs a great newsletter where people advertise distress sales. So that's a great place to start for a lot of people who are just getting in the business, or they can peruse to see if there's Article 9 sales, bankruptcy sales, and the like. Richard, I want to turn to you. When buying distressed assets, there are a variety of ways to structure a purchase. Can you generally walk the audience through the different ways a buyer can purchase distressed assets, both outside and inside of a bankruptcy case? And I'm going to refer to slides 13 and 14 in the deck.
Sure. Thank you, everyone. There's a couple ways, as that said, to purchase assets in and out of bankruptcy. In bankruptcy, you can purchase assets through what they call a 363 sale, which means it's a section of the bankruptcy code that authorizes the debtor to sell all or substantially all or even part of their assets free and clear of any liens, claims, and encumbrances. And I'll get back to that free and clear provision later in the broadcast. What the 363 sale does is that it provides a buyer with the comfort that a federal bankruptcy court order is blessing the sale. So what that means is that in a bankruptcy case, all the debtors, creditors, equity holders, anyone who could have a potential claim against the debtor has to get notice of the bankruptcy case. And if a debtor is selling its assets through a 363 sale, all those same parties have to get notice. And the reason for notice is that a bankruptcy court it's going to be a two-part process for selling assets in bankruptcy. It'll be what they call a bidding procedures hearing, followed by the sale hearing. Now, at the bidding procedures hearing part of the sale, that sets up the floor. For instance, if there's a stalking horse bidder, it'll set up minimum overbids, the amount of a breakup fee, expense reimbursement, that the assets will be sold as is, or what assets, and also what assets will be sold. And then there'll be an auction if there's competitive bidding with the stalking horse. Then there'll be a separate hearing called the sale hearing, where the bankruptcy court confirms and approves the 363 sale. The reason for that approval order, the reason why it can be sophisticated or non-sophisticated parties like that order, is because it shows that everyone was provided notice, and anybody who had a chance to object had their opportunity to object or question anything about the sale. And the debtor and the purchaser is now the owner of those assets free and clear, what they call NewCo. And anything that they didn't purchase remains with the bankruptcy estate. Another way to purchase assets in a Chapter 11 is through a Chapter 11 plan of reorganization. And that's a little more involved and expensive because a plan has separate requirements under 1129 of the bankruptcy code where different provisions of the statute have to be met. And that takes a longer time, it costs more money, and a lot of these sales are occurring when debtors don't have the financial wherewithal to run those planned sale processes. Now, there are many times a plan could make sense in a sale context. One is to get the benefit of getting a waiver of any transfer taxes or not having to register certain securities. And then other parts of buying assets in a bankruptcy are piecemeal. It could be the debtor is selling equipment, depending on whatever company it is, selling its equipment, selling its customer list, selling intellectual property, whatever's not nailed down. And again, these same processes of the 363 purchase order, or the not purchase order, 363 sale process apply to each one of those. And finally, there's another main one that is, I don't want to say a gold mine, but it could be it's an untapped resource that, again, if you're getting started in purchasing assets out of bankruptcy, looking at Chapter 7 cases, where that's a straight up liquidation. It could be a liquidation of a company or an individual who has several interests in a company. For instance, if an owner has equity interests of a company that the equity of the company itself isn't in bankruptcy, but that individual is, that equity interest is part of that debtor's bankruptcy estate and could be purchased to get a control position in the non-debtor company. And generally, because there's a Chapter 7 trustee and the debtor is not in control, you can basically work with the Chapter 7 trustee who's working on a commission. And if you have a decent price and leave something for the distribution to unsecured creditors, you can get assets that way. And I'll just say that one other point I want to make that's very important in these 363 sales. If you're a lender and you're looking to purchase all these assets out of bankruptcy, or you're a competitor and you want to run the company and run a sale through bankruptcy, you're going to have to what they call pay the freight. You're going to have to pay administrative expenses for professionals and U.S. trustee fees to run during the case, and provide some sort of recovery to unsecured creditors, because judges are not going to they'll work with you on a sale, but they're not going to rubber stamp it if the only person benefiting is the buyer or a senior lender. Now, to go back to the non-bankruptcy sales, these can be done out of a workout agreement with a company and their lender and their largest creditors. The advantage there is that it's all private. There's no you don't have to run to court. The disadvantage is that 100%, basically 100% of your creditor group has to agree to that workout or that purchase. And one recalcitrant creditor, it could be the smallest one in the group, could derail the whole deal. Another aspect is the assignment for the benefit of creditors. And again, a lot that's state specific, and a lot of states are using sort of have adopted bankruptcy forms to get a 360 in terms of a 363 sale type order, where it would be deemed free and clear, or as close to free and clear as it could be. And then you have, a straight up asset sale. Like I'm doing one right now. It's out of court. It's a simple purchase and sale agreement. Parties are negotiating the purchase price and what condition they're buying the goods in. And that's a quicker sale. And for that, again, I think it's different degrees of complexity. Sometimes the air quote simpler deal can be the harder one to get a sale through, and the more complex one can actually be the easier one. I know that sounds, counterintuitive, but if it's the complex one and people sort of know or the parties know where things are going to play out, people sort of pick their battles. And the smaller ones, um, for instance, if you're doing an out-of-court workout or doing an ABC or a straight-up asset sale, if one creditor is not getting paid, they may want to do everything they can to derail the process, so that they get a piece of the pie that they otherwise normally wouldn't get. So those are just the options that you have to buy purchase assets in and out of bankruptcy. And when I say assets, I mean hard assets, not equity interests. Although you can buy equity interests in a company or an entity in and out of bankruptcy, but those purchase agreements are a little different. You have to put in some different covenants and protections when you're the buyer.
Awesome. Well, thanks, Richard. I appreciate that. And John, I want to get to you. So every deal is fact specific, but what are some of the important considerations and risks that a buyer should consider in an out-of-court acquisition scenario? And slides 12 and 15 of the materials mention several of those.
So when I'm buying or representing a buyer of distressed assets, I I start with the premise, can we do this out of court, or at least out of a bankruptcy? Because as Richard said, bankruptcy is expensive. Also, depending on how you do it out of court, you may be able to avoid competition from other, or minimize competition from other would-be buyers. That's a good thing. However, because an out-of-court acquisition doesn't like a bankruptcy or even an Article 9 sale done right, unless you're talking about an Article 9 sale when you say out of court, right? The more private the transaction, suffice it to say, the less competition it might be and the better price you may get. But the more private the transaction, the less of an opportunity you have to clean up debt. And you don't want to buy subject to debt unless you do that knowingly and you know what you're doing. So for example, if I can buy a company's assets through an Article 9 sale, then I know I can clean up any junior secured liens, but I better make sure I do it right. I've got to do a lien search. I've got to make sure we notice all the other secured creditors, that kind of thing. If the company in question has certain kinds of debts, then bankruptcy, that may counsel in favor of a bankruptcy. Union obligations, real property leases. If the acquisition target has leases that it needs to overpriced leases that it needs to get out of or renegotiate, bankruptcy is usually the better place for that. There are certain powers inside of bankruptcy that you just don't have outside of bankruptcy. And when it comes to whether it's leases or other kinds of contracts or just or just other assets, you can sometimes better cherry pick inside of bankruptcy than outside of bankruptcy. What else can I tell you? We should probably talk about successor liability and fraudulent transfer.
Yeah, and John, I'm going to get to that in just a second. So if I could turn to Peter real quick and ask Peter, a significant risk in out-of-court acquisitions is fraudulent transfer risk, as John was just mentioning, and those are creditor remedies at law. How does a buyer protect itself against fraudulent transfer risk? In other words, how does a buyer avoid the seller's creditors, seeking to unwind the transaction after the fact, basically nullifying the deal that you just did?
Yeah, I mean, so a purchaser who buys distressed assets through an out-of-court acquisition can't ever completely protect itself from fraudulent transfer risk, but there are a few things that purchasers can do to help mitigate it, right? I'd say number one, just like when you're looking at particular asset, you got to do your homework, right? Run a lien or a title search to see if the assets being sold are encumbered. Now, if they are, it doesn't mean that the seller has any sort of fraudulent intent in trying to sell the asset, but it should prompt the purchaser to ask questions about, like, what's the motivation for the sale. And then when you get into like larger deals, obviously you're going to want to engage experts, like an appraiser or a banker, to help assess the value of the assets being purchased. Now, the reason why you want to do this is because it can help establish that the purchase price that you're paying is fair and market-based, which is needed to defend against an action for constructive fraud, where really one of the main elements is that less than reasonably equivalent value was paid for the assets that were being transferred. So to that end, transactions with suspiciously low prices will likely raise red flags to creditors about the seller's motivations or financial conditions. And then when it comes to like the structuring the actual sale, right? It's important to ensure that the terms of the transaction are well documented and transparent. So one thing that I would advise a purchaser to do is get the seller to make reps and warranties in the sale agreement that the transaction was not made in avoidance of creditors, and that the sale price is fair and market-based and reasonable under the circumstances. Now, this, of course, doesn't stop a legal claim from being asserted against the purchaser by creditors, but if the seller breaches these reps, the buyer at least has some recourse against the seller by, trying to get damages. Another provision that I would negotiate for in the sale agreement is an indemnity, which would require the seller to indemnify or compensate the buyer in the event that fraudulent transfer claim is brought after the deal closes. And then finally, one thing that you see often is the use of escrow services, right? So in some cases, the buyer can work with an escrow agent to hold a portion of the sale price in escrow until certain sale conditions are met after closing. For example, that there are no claims brought against the buyer within a certain period of time post-closing. And what this does is it just adds a layer of protection for the buyer.
So a question for all of you: how often do you see transactions unwound as fraudulent transfers? That phrase gets thrown around an awful lot, but how frequent is it that these, a third party transaction gets unwound as a fraudulent transfer?
It's very rare. And one of the reasons it's very rare is it doesn't take a rocket scientist lawyer to do the process right. And if you conduct the process correctly, then you really do a lot to insulate a sale from a future attack.
Are there any types of transactions that you guys see where that are more susceptible to a fraudulent transfer attack? So, for example, somebody who's running a fraud, right? Is that like, an admitted fraud? Somebody that gets charged with criminal indictment, something like that.
It's a bad fact.
Yeah.
Yeah.
Any insider transaction is going to be, looked at more closely, is susceptible to being looked at more closely. So, it's not uncommon, whether it's in bankruptcy or out of bankruptcy, but I think we're focused on out of bankruptcy still, for Newco to be owned by some of the same owners as Oldco is. And that's not inherently that's not disallowed. It's not even inherently wrong, but it is going to be both practically and legally subject to higher scrutiny. Because, I think for obvious reasons, but the way to deal with that situation, the way, if you're representing either the buyer or the debtor that's selling its assets, commercially reasonable process can, the sunlight of a commercially reasonable process is what's protective. So if you can show that you conducted a fulsome and fair sale process, then that is, courts almost universally view that as tantamount to proving fair market value, because something is worth what a reasonable buyer will pay for it. And so as long as the opportunity was marketed well enough and other aspects of the sale are conducted in a reasonable manner, that's sort of the best defense against a potential future attack.
I appreciate you jumping in on that, John. Richard, I want to go to you next. And one of the things that John mentioned a little bit earlier was successor liability, and we hear about successor liability. It gets thrown out there like fraudulent transfer risk. So what is successor liability? Why is it an important issue? And in what types of scenarios would buyers have potential successor liability concerns?
Sure. Successor liability is essentially when the Cliff Notes version is when a buyer of assets, of whether distressed assets, is, becomes new co, and certain liabilities of old co become liabilities of new co through what they call successor liability. And where the biggest areas where this is litigated are collective bargaining agreements among unions, uh, pension funds, particularly if pension funds are underfunded, and certain environmental risks. Most buyers of assets will not for instance, let's just use the collective bargaining agreement example. For instance, all collective bargaining agreements, have end dates that need to be renegotiated. At some point, if a buyer buying assets and there may be a year or 3 years left on the collective bargaining agreement of a particular union, a buyer may not want to take that contract because he doesn't want to deal with the union negotiations and the what could come of a new collective bargaining agreement. And this is one where buyers usually say, no, we're not going to take the assets subject to the collective bargaining agreement. It has to be, rejected. Or, and this is a separate provision of the bankruptcy code, where a debtor could provide their latest and best final offer, and through the bankruptcy court, a debtor could close and impose those terms on the union through the collective bargaining agreement that the debtor wants. That's expensive and subject to a laundry list of litigation, particularly just look at the airline cases. And normally buyers will say, no, we're not going to take not going to take the company subject to the CBA. Pension funds, similar type of issue, but also particularly when they're underfunded. And the issue there of a buyer is that, and let me just step back for how separate claims are treated in bankruptcy. You have your priority claims, you have your administrative claims, secured claims, general unsecured claims, and equity interests. Equity interests usually get wiped out. General unsecured claims usually get paid a pro rata share, rarely ever in full. Secured claims, they could be taxes, they have to be paid in full. Secured claims, including, a senior debtor in possession loan, that has to be paid in full. Priority claims, that could be many categories of wages, certain goods, and administrative claims are basically any claim that occurs during the bankruptcy case. And for instance, it could be a lease or it could be just a vendor. Those post-petition claims are what they call administrative expenses, and they have to be paid out as part of any bankruptcy case. And normally what happens with now keep in mind what I said about administrative claims. They have to be paid in full unless an administrative creditor agrees to a lesser treatment, which is rare. The underfunded pension that I mentioned earlier, and let's just say the pension fund's underfunded, the buyer will not want to take that liability of the pension fund. One, because it's underfunded, and the buyer would have to make up the difference or the whole of what is in that pension fund. And so that's where it's aligned with similar treatment of a collective bargaining agreement. However, if you terminate the pension fund during the bankruptcy case, there is split case law on the pension fund. There's what we call withdrawal liability damages. And I'm glossing over a whole host of specifics, but I just want to make the point for what the buyer has to look at. So when a debtor says, okay, buyer, you don't have to take the pension fund, we're just going to terminate it. And the United States government, the PBGC, has to come in and administer the remains of the pension fund. So you would argue that, oh, the pension fund has a general unsecured claim. Not necessarily, because that pension fund contract rejection doesn't happen until later in the bankruptcy. It could be a day, it could be several months, it could be a year, 2 years. However, the pension fund will have they will have what they call a withdrawal liability claim against the debtor. Now, there's several cases of which portion of it is administrative, it has to be paid in full, or which portion is not administrative, it's a general unsecured claim and doesn't have to be paid in full. Now, even if you're not going to take that pension fund contract and you're a buyer, you want to do the diligence of basically how much that withdrawal liability claim as an administrative expense claim would be tagged on the bankruptcy estate that you as a buyer would be on the hook for, because most buyers, not only do they buy the assets, they would either have to leave enough to cover administrative expenses or assume certain liabilities. And so that's where the successor liability issue comes up. And if there is not, now getting back to what Dad said at the very beginning of this conversation, so if the successor liability, if new co is deemed the same as old co, then new co is liable for that underfunded pension, the whole thing, administrative expense claims and the general unsecured portion, whatever way it comes out in any termination litigation. So there, the new co is now stuck with a big liability that they didn't want during the bankruptcy. It would almost defeat the purpose of why they want to buy the assets or the company in a bankruptcy case if they have to take on this big liability. And there's usually language you put in the sale order and different aspects where the new co is not deemed the successor of the old co. For instance, management usually changes over. Contracts are rejected, leases are rejected. What else? There's essentially a new company, but it's not the same as the old company. If that makes sense. But that's where usually successor liability comes up. And really where you see it become a problem is in the more complex, sophisticated deals where you have a private equity sponsor of a company. Say let's pick ABC Private Equity Corp. They have one of their managing directors on the board of the debtor. The debtor files bankruptcy, it does an asset sale or does a sale, and NewCo has that same board of director on the NewCo. Is it successor liability? Well, the true lawyer answer it depends. Like, is that managing director of that ABC private equity fund, how big of a role do they have in the day-to-day activities of the company? Did they tell the managers which vendors to pay, which, what products to sell, which products not to sell? Do they hire and fire everyone? So it really depends on the involvement of the new co, and that gets to what Jonathan said earlier about an insider purchasing a company. It's not per se illegal or frowned upon. It's just more diligence has to go into it.
Yeah. So Peter, John, anything to overlay on top of what Richard was just talking about on successor liability?
I'll just say that if we take a step back and look at the forest as opposed to the individual trees, the way I always think about it and explain it is successor liability has sort of two sources. One, which Richard talked about a bunch, labor, employment, product liability. These are areas whereby statutory law, statutes have created strict successor liability upon certain buyers, period. And then sort of the other arrow, the other major bucket is when successor liability is found, let's say on equitable grounds. It's not based on a statute per se, but it's some creditor comes and presents themselves and says, what this seller did in selling to this buyer, it's not fair. and there's a litany, there's a multi-factor test as to, what factors have to be, checked, found for a court to say, yeah, you're right, this isn't fair, I'm going to tag this buyer with successor liability. It's not that the buyer didn't pay enough money. If that was the case, that's a fraudulent transfer risk. A successor liability risk can occur, can be present even if there is no fraudulent transfer attack. Typically, all the different factors that go into whether or not a court will say, yeah, this is not fair, I'm not going to allow it. I think almost invariably, the most important factor on every court's list is there substantial overlap between the owners of old co and the older owners of new co? If there's absolutely not, and it was truly a arm's length transaction, it's going to be far more difficult for some plaintiff to successfully argue that the buyer should be held as a successor and liable on that theory. Once that factor is present, though, there then it kind of basically what courts ask is this new co getting all of the benefits that old co had? Does it enjoy old co's reputation? Is it from a third party stranger, if they look at the business, can they not even tell that it's now owned by, it's a new company with new owners? And the answer is no. That's what then it tends towards, a viable case for successor liability.
Yeah, totally agree with that. So John, I want to switch gears a little bit here, and talk about nuts and bolts of acquisitions. And one of the strategies that we hear people talk about a lot is the quote unquote loan to own strategy. It's used loosely in my experience. People just use it to describe a bunch of different scenarios. So, from your perspective, what is it? And how does the fulcrum security play into that strategy? I'm going to reference slides 16 through 21 and 25. And then one other question here, John, is a loan to own strategy more common with certain sizes of companies and certain asset classes, as opposed to being used more broadly across a bunch of different industries?
Sure. So, first, sort of a fundamental principle of commercial law is that, most companies of any real size borrow money to operate. They've got a credit line, they've got some sort of a credit facility. And it's customary and it's customary, almost to the point of being universal, that a company that has a loan from a lender, bank, or some other kind of lender like that has pledged substantially all of its assets to its lender, and its lender has a first priority security interest by filing UCC ones with for personal property and real estate, county deeds get filed, right? So that's like it's just a truth. It's a data point of how how the world works. A loan to own strategy involves a party coming in and either making a loan not for the primary purpose of earning interest, or buying a loan from an incumbent lender, and for the purpose of potentially being able to effectively foreclose on all of the assets of the company, of the borrower, and take it over. So if a company is, let's just assume that everybody at the figurative table agrees that a company X, is worth $100. And if that today it's worth $100, but for whatever reason, its senior secured lender has loaned it $150, then that senior secured creditor can effectively credit bid its debt, and it will own the company at the end of the figurative day. It can end up owning the company, and nobody else can properly complain because it was owed 150 and it only got 100. That's assuming that we all hypothetically agree on the facts of valuation, but nobody ever agrees on the facts of what's the real value is. Let's take the opposite example. If a company, the same company, everybody agrees for argument's sake it's worth $100. Everybody also agrees that the senior secured lender is owed only $50. So in that case, and I didn't define fulcrum security yet, but I guess I'll do it now. It's the point in the capital structure where the debt, where the value of the company runs out, if you will. So in the first case, I can tell you that the senior secured creditor is definitely not the fulcrum security. Excuse me, it definitely is the fulcrum security because it's owed $150 and the collateral is only worth 100. There's no value available for anybody else. In the second example, where the lender is owed $50 and we all have agreed that the company's actually worth 100, I can tell you the one party who is not the fulcrum is that senior lender. Who's the fulcrum? Well, who's next in line? Who's next senior? If there's no other secured lender, then the unsecured creditors are the fulcrum. If there's a junior lender who's owed $100, well, there's only $50 available for that junior secured creditor. That junior secured second lien creditor is the fulcrum. And the point is, although debtors can fight about it, if at the end of the day a company is worth less than it owes its senior secured, that senior secured can, or forget the senior secured. It's the point is that if the company is sold and the proceeds are available to pay off the top tranche of debt, let's call that the senior secured, then the party who doesn't get paid in full is the fulcrum, and that's the party that can, if it has a secured lien, it can credit bid at a sale and buy the company if no one will outbid it.
Yeah, that's very, very helpful. Peter, Richard, anything to add? Okay. So Peter, we've been talking about the risks of an out-of-court acquisition of a distressed company or distressed assets. Does purchasing distressed assets through a Section 363 sale, which we've talked about today in a bankruptcy case, remove the risk factors we've been discussing, right? Free and clear, negotiate away the potential liabilities, right? And what are some of the risks that you've come across in your deals over the years that you may have been able to mitigate by acquiring the assets through a bankruptcy sale as opposed to an out-of-court transaction?
Sure. So, I mean, I'll take the questions kind of in reverse in terms of risk mitigation through a bankruptcy sale order. I mean, one thing we just talked about is, successor liability. It's the biggest risk that my clients have been concerned about. And a free and clear sale order under the bankruptcy code really offers the best way to reduce this risk. You have, this is something that you have access to through a bankruptcy process that you don't out of court, say an Article 9 foreclosure. So under Section 363F of the Bankruptcy Code, interests in property of the estate can be sold free and clear. And generally, courts have construed the term interest pretty broadly to not just pick up liens, but also certain claims and successor liabilities. And then in addition to 363F, there's 363M, which provides pretty much an almost ironclad defense to attempts to undo an approved sale on appeal. And under this section of the bankruptcy code, the sale is not going to be unwound so long as the purchaser acted in good faith and the sale wasn't stayed. We also previously talked a lot about avoidance actions and attendant liabilities. So in several cases, I've suggested to purchasers that it would be helpful for them to purchase avoidance action claims from the debtor and then choose not to pursue them. That's often called bearing the claim. This strategy is helpful for buyers who want to protect themselves from lawsuits involving vendors and other parties related to the business that they are acquiring. And note, however, that some courts are of the view that a debtor cannot sell avoidance actions because those actions belong to the debtor's creditors and therefore not property of the estate. So, while a free and clear sale order does go a long way to remove, these risks that we've discussed, it's not a complete bar. So, one thing that you see sometimes, especially like when you're dealing with future product liabilities, is claims by parties who did not receive notice that they had a claim at the time that the sale took place are generally not subject to the sale order. Like this was a big litigation in the GM ignition switch litigation before the bankruptcy court. And courts have reasoned that in these circumstances, these claimants are not really parties to the bankruptcy, and they have not received notice, and their claims do not attach to the property being sold. And this is really an extension of the due process clause of the Constitution, which requires notice and an opportunity to be heard. And then sometimes you'll see in the environmental context, the environmental regulations can impose obligations on the purchaser, particularly if the purchaser is deemed to be a successor under environmental law. The purchaser has to operate the site that it buys in compliance with environmental law, even if the debtor did not, which may require the purchaser to take steps to, say, remediate environmental contamination. So those are a couple of instances where, that the sale order doesn't completely cleanse those potential liabilities.
Yeah, great. And Richard, I want to get, because we've only got about 12 minutes left, I want to have you explain for the audience the general sequence of events and the typical timing in a Section 363 sale, and at what points in the process do there tend to be complications for prospective buyers? I'm referring to slides 31 and 30 through 33 of the slide deck.
Sure. So again, I think buyers want sales done fast. I'll go back to the crisis of 07, 08, 09. I had one sale where from petition date to closing date was 37 days.
The fastest one is under 48 hours.
Yes, that and I was but those are anomalies. Those are what they call the melting ice cube sales. And not what I mean that the company is literally falling apart. It's that there may be only one buyer and these are the terms, and it's sort of a take it or leave it deal from for the debtor. But normally I know the slides give various days, but I'm going to break it out into between the filing of a stalking horse motion or a bidding procedures motion to a sale hearing and closing, generally about 100 days. It's going to be, give or take 10 or 15 on each side. What's going to occur first, if you have a stalking horse bidder, which the stalking horse sets the floor for the sale of the company, meaning the debtor is guaranteed X dollars for a purchase price if no one else shows up at an auction. And with the stalking horse, they'll want, they'll negotiate the asset purchase agreement. The key points, they'll want a breakup fee and an expense reimbursement, because if the buyer is doing all the diligence, or the stalking horse is doing all the diligence really to benefit someone else, they should be compensated for it. Now, stalking horse purchasers can get a little greedy. and ask for, sort of the moon in terms of a break fee and expense reimbursement. Normally a
And some of
breakup.
those, Richard, by the way, are set out on the slides, right? In slides 23, 24, 26 through 29. So yeah, the audience can view some of those.
Sure. And you basically put in the asset purchase agreement, the seller is going to want the most pro-seller provisions, that things are as is, there's no reps and warranties. The managers will say, hey, we don't even know this company, and the buyers will want uh, sufficient notice that they were told everything, that they were provided notice, that there's reps and warranties, that everything they did their diligence on is the universe of the company when they know they're buying the assets as is. So normally, when you have a bankruptcy and you file the stalking horse or bidding procedures motion, sometimes it's filed on the first day of the case. Sometimes it's usually filed a few weeks into the case, and a separate creditors committee will usually be appointed during that time. And the first thing the creditors committee will do is saying, "Hey, did you market this? The timeline is too short." Gets into the due process argument that Peter brought up. Um, and normally there's a give and take between the debtor and the stalking horse purchaser, really to stretch out the timeline a bit and maybe cut back on the expense reimbursement and breakup fee. And then that's, give it another 21 days um, to get court approval for that bidding procedures and stalking horse bidder. And then in that bidding procedures, there'll be outline the terms for the auction, date, what a proposed competing bidder will have to provide. Usually it's a markup of the stalking horse agreement. They sign a confidentiality agreement to get into the data room to do their own diligence. A certified funds that they have the financial wherewithal to close the transaction. Now, closing is not just having all the money. If you're in an industry that requires regulatory approval, this is where sometimes being the highest and best cash offer may not be the best offer for the debtor, because a lower bid that can get through regulatory approvals may actually be the better bid for the estate, because they can get a regulator to approve the sale outside of the bankruptcy court or in conjunction with the bankruptcy court.
Yeah.
Then,
So Richard, you just laid out a bunch of really good positive things, and in particular for stalking horse bidders, right? John, Section 363 sales really, aren't all roses and butterflies, right? They aren't without risks, pitfalls, and downsides. So why would a buyer want to avoid purchasing a company or its assets through a Section 363 sale? And I'm going to commend slide 38 to the audience. Oh, you're on mute, John.
Sorry about that. So a 363 sale is likely to get maximum competition as compared to every other alternative. As we said earlier, outside of bankruptcy, generally speaking, less competition than inside of bankruptcy. Inside of bankruptcy, as between a 363 sale and a purchase under a plan, if the buyer can work cooperatively with the debtor, then you can effectively buyer can effectively purchase a company through a Chapter 11 plan during a debtor's period of exclusivity and largely avoid competition. I mean, there's a whole bunch of, gating rules to make sure that, buyers can't steal companies this way, but it is a way to limit competition. Notwithstanding the fact that most of the would-be buyers that compete in 363 sales are economically rational actors. History tells us that even the most economically rational actors during an auction can emotions or less than completely disciplined decision making can really cause prices to be driven up in the context of an auction, where you may be the stalking horse. Well, whoever you are, you may be the winning bidder, and then you may have immediate buyer's remorse. The stalking horse, those issues are addressed towards, should I buy through a 363 at all? Or as a potential buyer, should I try to guide the overall process away from that? If there is going to be a 363 sale, and I know I want the assets, or my client knows it wants the assets, although stalking horse status brings obligations like, you're going to have to be a backup bidder if no, you're committing, subject to usually a very small number of outs, to be the buyer of last resort. If you're trying, one of the reasons you get bid protections as a stalking horse is the theory is that you're making sure there can be an auction, because at least an auction that's going to result in some minimum amount of proceeds, i.e. your purchase price if no one comes to outbid. But and also, if you want to own the business, it would have been better if you could avoid the public nature of exposure. A lot of competitors, other would-be buyers, can come and do their due diligence against the assets you're buying, and if you want to wind up the owner, you might like to avoid that kind of exposure.
Yeah.
Just to get on
Those
what
are some
Jonathan,
of the reasons.
I think one thing Jonathan brought up, the backup bidder, and if you're the backup bidder, the debtor, and I've know this from personal experience, can use you as a sort of a ping pong if they want to get their original buyer back. That's one of and having litigated that issue, courts will usually say, you're a whiny bidder, you can't get, you're not entitled to the assets. So that's one of the other big risks I was just thinking of.
Yeah, well, and I was going to ask Peter, about lenders, right? There's always the fear that a lender is going to credit bid, right? Does that possibility of a credit bid factor into your decision making when you're trying to, purchase assets through a 363 sale? Do you go to the lender to potentially buy their debt, so that way you can, ensure that they're not going to show up and you're going to be the one controlling the process?
Yeah, I mean, certainly the possibility of a credit bid leads you to need to consider like a bunch of factors. Like if you know that a secured creditor is going to show up and credit bid, and you come to the auction, like there's a good chance that you may get priced out, because secured creditors can credit bid up to the full value of their secured claim. So they don't have to show up with cash. They can just flip their existing secured debt for the assets, assuming that the credit bid becomes the winning bid. It also, of course, raises the possibility that a secured creditor could end up serving as a stalking horse bidder. So really, the buyer in that situation has to assess whether they want to compete with a credit bid. If you're a potential buyer in that situation, you have to assess whether you can outbid them in cash or come up with some other structure that will make your offer attractive to the debtor and its creditor constituencies. So it's like you find yourself in a pretty tough position, especially when the secured creditor does want to credit bid. I have seen in some cases where the secured creditor has really no interest in owning the assets through a credit bid, that they may come in and make an initial bid through a credit bid that's like a fairly low amount, just to kind of get parties interested and to promote robust bidding. But if they want to come in and exercise their full ability, exercise the full amount of their secure claim through a credit bid, it's you find yourself in a tough spot.
Well, guys, this hour has gone very quickly. I want to end with, a question to each of you, which is, we've talked a lot today about ways that and issues and concerns and challenges that buyers might have when they're looking at buying distressed assets. Do you have any words of wisdom for parties that are looking to make profit under the circumstances, and jump into an opportunity to buy, a distressed company or distressed assets? And I'll start with you, John.
Well, always remember you typically make more of your money on the buy, not the sell when you're buying distress. So you got to buy at the right price. And part and parcel of that, and really the threshold question of whether you want to buy at all is, is the target experiencing liquidity problems or fundamental insolvency? Are they problems that can be fixed, or are they problems that can't be fixed?
Yep. Wise words. Richard, what about you?
As you get more experience in buying assets, you realize some of the best deals are the ones you may not have purchased. I think a lot of buyers get caught up in the idea that, oh, I lost out on that bid, I lost out on that company, I lost out on this. Sometimes not getting the asset is probably the best thing. I'll give you an example, quick example. A bunch of the movie theaters that went bankrupt during COVID, I had a client that really, really wanted one, didn't get, didn't really make it to the auction. Turned out to be the best thing because the company, I'm not sure if it went back into bankruptcy, but the numbers weren't looking good for it. So it didn't get stuck with that.
All right, Peter, how about you?
Yeah, I think, look, just to piggyback a little bit off of what Richard said, yeah, I think it's really important for you to do your due diligence up front. Because if you need to really take the time, learn about the asset. And so because you could find yourself buying something that could be really bad for you down the road. I think it's important for you to like really make that investment up front, because it could save you a lot of headache and potential loss of money on the back end.
Awesome. Well, we hope you all had fun today, and we hope the audience had fun as well. Slides 5 and 65 remind the audience that they cannot go out and make important business decisions based on what they learned here today, if anything. We're not your advisors. You're not our clients. This stuff was meant to give you general knowledge and to help you select and work with really talented advisors like John, Richard, and Peter. So this concludes our webinar. Thank you for joining another entertaining and educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks again, guys.
Thank you.
Take care.